in having this conversation. And feel free to take the conversation offline as well. I'll hang around. And I hope you haven't eaten such a heavy lunch and you'll be able to participate. Thank you.
Good afternoon. My name is C.Mputhia of C.Mputhia Advocates. We are a firm that specializes in intellectual property, especially in the innovators field and entrepreneurship. We also have an initiative we began this year known as iPropex. It is an ideas exchange or intellectual property exchange in Kenya where we work with innovators. We, of course, mentor them and we help them commercialize their innovation. So I'm very glad to be here this afternoon. Thank you.
So I guess, Kathy, we can start the conversation. I think we were requested to restrict ourselves to GDPR and in the context of AI. So I think one of the things we were asked to address is how, well, maybe even before we talk about the data subject rights, what's the relationship between AI and data? Why are we talking about privacy? What's the correlation?
Like earlier speakers told us, data is a very, very big part of artificial intelligence. And particularly on our topic, there's a lot of data mining when it comes to machine learning systems. And when it comes to legal issues, there's a lot of regulation concerning data privacy and you know, issues that we are going to touch on data mining and all that. So GDPR, which is actually our topic, is these are regulations that the European Union passed, that is last year, 2018. Of course, Kenya still doesn't have GDPR, that's General Data Protection Regulations, but GDPR regulation will apply if you are offering services to any member of the EU. So we, I'm sure, like my name's Sekia, I'm sure she has clients who are based in the EU, or if you're planning to globalize and you're looking at that market, the GDPR regulations will definitely be applicable to you and they are compulsory.
Yeah, precisely. And in this day and age, it's very hard for an organization to say, I mean, how many organizations can say, we do not offer services to EU citizens and therefore GDPR does not apply to us? That's a very tough thing to say and hard thing to say. So obviously you will find that most companies have been trying to comply with GDPR. I know the enactment came into force in May or 2018, and now many companies a year later are still grappling with GDPR compliance. And the beauty of GDPR is it's not a one-size-fits-all, and that's why many companies are still struggling with GDPR. And from the legal perspective, the GDPR provisions are subject to a million interpretations. A million ways, and as lawyers, we could stand here and you bring a piece of paper that's orange, and a lawyer will convince you how it's color purple. So because of that, while we're working with our clients, we'll tell you some of the things the clients deal with, because GDPR is not a one-size-fits-all, it's interpretations. And I know in many organizations, they work with the data protection offices to try and get interpretation, and many organizations out there are giving out, churning out interpretations of GDPR to enable companies comply, and we've also seen that with many organizations here. So now that we've done the correlation between AI and data and GDPR, and also perhaps we should have mentioned that the personal information is what GDPR tries to address. GDPR tries to give power to the individual whose information is being used. And as we know, many AI companies use personal information or personal data to build on their models and their systems. And hence they grapple with all these legal issues. Currently in Kenya, there is also a data protection bill. And this is probably maybe the 10th year since the first bill was tabled. So, but it's a good thing, I guess, because it means given the conversations that have been had around the bill, so hopefully when we get an act eventually, it will be watertight. And as we have seen, currently the bill sort of in a way mirrors GDPR. So maybe we can look at data portability. That's a huge thing because for the AI companies or for the companies that are leveraging or harnessing processing data and using and leveraging on AI, data portability is a huge issue. And obviously, you can tell that what they aimed at is to improve competition and to allow data subjects to transfer their profiles, so to speak. So then, how then would you say data portability rights impact the various industries? The people, our audience today here come from various industries. You'll be from banking, you'll be an AI firm that provides third-party services to someone else. How would they know how data portability impacts them and in what ways?
Okay, thank you, Kathy. I'll stick to what I know, and I'd like to see how data portability will affect the legal industry. So to start with, and Kathy can testify here that I don't know how many lawyers are in the house, but we are lagging behind in digital transformation. So not many law firms are digitized, but assuming that we are working with a digitized law firm, and a law firm that's offering services in the EU, therefore GDPR is applicable, and the right to data portability. So one of the things I think will impact my industry is there'll be improved data governance in terms of law firms will have to restructure their ICT, so to speak. Currently, the practice is data privacy and data issues are handled at the IT level. But with these rights under the GDPR, then we'll see issues of data privacy going to the board level, and it will cut across all departments because data privacy is not just an issue of the IT department. We are talking of marketing, HR, and all other departments which receive data from the customers. And in terms of legal, I'm also thinking our clients will have, how will I put it? Consumer rights will be upheld because almost in all industries, clients have the right to receive information. Our constitution, actually, the Kenyan constitution, gives this as a constitutional right. I think it's Article 43, where you have the right to information. So those kind of consumer rights will be, so to speak, upheld. Now, very specifically to my industry, and this is my personal opinion as a practitioner, I think there are a bit of intellectual property issues that will come up with this data portability because this right entitles my client to ask for his data or for, any product I've come up with using his data, and my client will be able to use it or transfer it to a third party. So we are looking at a client telling me, give me whatever you've come up with, I'm giving this other law firm. So as a lawyer, I think of my intellectual property rights. I've spent time, I've spent money, and probably I've invested in AI to come up with all that. So it's a gray area about balancing the client rights and my IP rights as a service provider. And with that, I'd also think of unfair competition. In the sense that, okay, I've invested, again, my time, my money, my intellectual resources into coming up with this, and then it's just taken and given to somebody else who has not put in the same kind of resource. So those are some of the gray areas about the impact of this. Again, it's a very new thing, so we wait to see how it will play out.
Yeah, precisely. And just to beef up what you've said, data portability, because we lawyers are accused of using a lot of legalese and leaving people out of the conversation. So just to clarify, GDPR basically provides that a data subject can request someone, a processor or controller, who's holding, a data controller who's holding their information, their PII, to transfer that data, of course in a certain format, to another data controller with consent. So obviously when you come to the practical aspects, and coming home, let's say you're dealing with two telecom companies, and I'm the consumer of the services, and I ask Safaricom to transfer my data to Airtel. So then in what format, and in the context of AI, in what format, and does it also include, let's say, like credit scoring? In what format will it be? And obviously Safaricom would be considering things like what trade secrets, their IP, when you transfer this, does it sell out your strategy, and would competitors use this to get people and actually approach people to get their data transferred to them so that they can get insights into the competitor's strategy. So all those are questions and issues around data portability. And you can tell that the reading of GDPR, the spirit of GDPR was to be able to enable the consumer or the data subject to harness advantages, such as transferring your profile, let's say in e-commerce, in insurance. So then people would compete to provide better products for your client. And why start something from scratch while someone else has valuable data which you can use on a certain data subject? But then it seems to be a double-edged sword, because those are the issues then that arise. And I'm curious to see what will happen in this case, because until there's a lot of clarity or a lot of litigation around this, and we have courts deliberating on these issues, like what about where a competitor gives the data to whoever it is, but it's not in the format that was required? Then what are the consequences? And so as I said, there's a lot of interpretation. We could sit here and talk about GDPR and interpretations, but I'm curious to see how that will play out, especially when it comes to derived data, because that's what happens behind the scenes. Like we know there are some companies that do the credit scoring and everything, so then can I take that and it be transferred to someone else? We've been talking about interoperability in Kenya. So then will we see it as a reality, since GDPR is very enabling of that? And there's also in the health sector, that's what is considered sensitive data. How will organizations deal with transferring such data? And of course, when you come to the the context of Kenya, there's also regulation, like regulation around those different sectors, which have additional regulation requirements. So I know companies are currently grappling with all that, and we will see how it plays out. But what I tell my clients is, from the word go, as you're designing the AI systems or whatever systems it is, as you're mapping out, design it in such a way that you can enable data portability. And so that you think beforehand, in what way, in what format, how would I be able to extract just the right information and the information that I'm obligated to transfer or to, as per the data subject's request, so that it doesn't compromise my data set or my system. So then you have to think beforehand and not wait until then, so that you design something that has that function.
Okay.
So then, apart from data portability, we also requested to discuss around privacy impact assessment. And we know under GDPR, organizations are required to carry out a data protection impact assessment where, you know, and obviously AI companies are subject of GDPR because of Article 22. And obviously, so companies where the fundamental rights and freedoms of natural persons, where there's a high risk posed to the fundamental freedoms of individuals, they're required to carry out a privacy impact assessment. So then what should organizations have in mind when carrying out this privacy impact assessment? And should it be a tick box, or should it be deliberate and thought out? And how can organizations also look at privacy impact assessments as a valuable thing, as a benefit actually to them, rather than an obligation or just ticking a box? What are your thoughts on this?
Yeah, so the data privacy, the impact assessments are compulsory. And once again, if you are providing services to the EU, you must do this privacy impact assessment, I think, periodically. And especially where you embrace a new technology, you must actually do this impact assessment. And there are other regulations. You can actually check the GDPR regulations. They're available all over the net. And without getting into the legalese and basically reading out the provisions, I think there are a few challenges in conducting this privacy impact assessments. And the first one is it's a very, very, very technical process. I was talking to somebody in the morning, I think somebody in IT, and he said actually one of the challenges that we are currently facing in this space is there are very few data scientists or people in that field. So when you're doing this assessment, you need to actually engage somebody who is technically trained, and that's according to the regulation. So I already see that as a challenge. And then I think it's also a very, very costly exercise to be able to meet this mandatory requirements. It's a very, very costly exercise, and I know AI mostly maybe is, I'm just assuming maybe it's startups or innovators who are in this field. So the question is, are you able to afford the cost of compliance? And then I also think it brings a lot of bureaucracy, a lot of delays in implementing new projects. Remember that when you're doing a project using a new technology, you must do this impact assessment. So now, having looked at the cost and the kind of technical expertise required, it might delay projects, because before you even roll out these projects, you need to have done this impact assessment. But looking at it on the positive side, if you're compliant, if you're GDPR compliant, for example, I don't know how to do it, but I plan to be GDPR compliant so that I'm able to market my services in the EU as a GDPR compliant law firm.
Yeah, precisely. And especially for organizations, when you carry out, I always tell my clients, when you carry out a privacy impact assessment, because you see GDPR says where a high risk is posed to the rights and freedoms of natural persons. So then organizations are like, what is a high risk? And GDPR did not provide the criteria quite. But we've seen many people, many organizations come out and list what is a criteria for high risk and provide what we call a blacklist and a whitelist list of items. But I tell my clients, you know, by you carrying out a privacy impact assessment, it shows your seriousness also as an organization, and you can actually use it for PR and to just show organizations how seriously you take, I mean, the seriousness you take holding their data and how you're willing to basically protect their data and how you're putting the information out there. Because remember, when you carry out, most organizations, when they carry out the privacy impact assessment, they actually publish. And we've seen in some countries where even government agencies are now carrying out, you know, like immigration holds a lot of data on you. And if they can provide privacy impact assessment, it just shows how serious they are about data protection and privacy issues. So when I advise my clients, I tell them carry out the privacy impact assessment. There are many considerations that go into it. It's better done by external, people who are externally from the organization, because then, you know, they're a bit impartial. But they are necessary and organizations should consider doing it. You shouldn't wait until you start a project. That's when you're carrying out a privacy impact assessment. It should be something that the organization continuously carries out, maybe every 2 years, every 3 years. I know our time is running out, but they also asked us to discuss about GDPR compliant data processing agreements. And basically the context of data processing agreement is you have a data controller who is a first party and they're receiving the source, where the first point of contact receiving the data from the data subject. And then you would find, like in the context of a financial institution, they are working with other parties in various functions. So then the other parties would be parties, and these third parties would come across the personal information in one way or the other, and GDPR refers to them as the data processors. Of course, since obligations are placed on the data controller, who is the person who's handling the information firsthand, they have certain obligations, and GDPR requires that these obligations also apply to the data processors, so that if you're GDPR compliant, your service providers and third parties should also be compliant. How this is connected is by having the data processors enter into a data processing agreement. So obviously, the importance of this is to protect the data controller themselves, as well as the data subject. So then, briefly, what are the most important things that have to be in a data processing agreement, or that the parties should ensure is covered clearly?
Okay, thank you. First of all, it's a contract like any other, and want to minimize legalese here, but there are those essentials of a contract. And again, the agreement, according to the GDPR regulations, there are certain mandatory terms that must be in that agreement. And I think I'd invite you to just look at the regulations. It is Articles 24 and Articles 28 to 36 of the regulations. And of course, things like the term of the agreement. How long are you going to be this processor? What kind of data is it going to process? Is it, all data? And again, that is also connected to the purpose. Why are you having this data processor? Is it to store the data? Is it is he profiling, or what are his roles? What are you having him for? So that needs to be in the agreement. And of course, as a data collector, there are those indemnities, or because as Catherine said, you would be liable for the actions of your data processor, and so you need to have all those clauses, and just look at the regulations. They have all that, and I think that's
precisely. And the data processing agreement, since the data controller is liable under GDPR, they're just transferring and making it known to the data processor that this is my responsibility for this data I hold. I am giving you access to this data, but you should know that you're also responsible in this way. So it would cover cybersecurity, reporting in case of a data breach. You'll notify me because I have this obligation under GDPR, confidentiality, for how long the data should be held and things like that. So a good data processing agreement is a must if you want to be GDPR compliant, because the main thing, as you mentioned, is you're held responsible for the actions of your data processor. I think the bell has rung twice. So should we take questions from the floor? You know, lawyers can talk the whole day, so we could keep talking and talking. But as I mentioned, we're glad to take this conversation off the floor.
Yes. Yeah, we have run short of time, so can't take any questions.
All right. Thank you very much.
Okay. Thank you.